An emergency action was just decided at the United States Supreme Court, concluding a massive, fast-moving constitutional showdown over digital privacy, state powers, and how every single American can access mobile apps. The case represents a massive battle between Texas and a broad coalition of student advocacy groups and major tech companies as well. This entire fight is over Texas Bill 2420, better known as the App Store Accountability Act. Now, this is not just a localized issue. This law mandates a fundamental overhaul of how apps function within the state of Texas, with ripples that will inevitably also hit the entire country. The Supreme Court became involved after the Fifth Circuit Court of Appeals stepped in, stayed a lower court injunction, and allowed Texas to begin enforcing this new law. Now, in response, an emergency application was filed to the Supreme Court, asking for the court to intervene immediately and block the law. And we now have the official response from the Supreme Court. So let's break down what exactly this law says and what just happened with the Supreme Court order. Now, before we break down what just happened at the Supreme Court level with this emergency order, if you like this type of content and you want to make sure that you get it going forward, make sure you subscribe to the channel and also turn on all notifications to make sure you never miss these videos when I release them. Now, to understand why this case moved with lightning speed at the Supreme Court level, we have to look at the mechanics really that played out with this law that was put in place in Texas. Now, this law is not a standard social media restriction. It targets the point of distribution, which is the digital storefront itself, where people get these apps. Under the text of the App Store Accountability Act, any digital marketplace offering mobile applications to users in Texas must implement a mandatory universal age verification framework. If the system identifies a user as being underage, a sweeping set of restrictions immediately locks down that device. So under the law and this process, minors are completely barred from downloading any new application, regardless of its content, rating, or educational value, unless a parent is verified and linked to that account. The law also explicitly outlaws blanket consent. A parent cannot simply log in once, sign a waiver, and give the kid permission to use the App Store freely. Instead, the law mandates a process of individualized, transaction by transaction actual consent. Every single app download, update, or in-app purchase requires separate parental consent. Finally, the law places strict limits on how platforms can actually track, profile, and monetize the data of anyone under the age of 18. If an app store fails to comply, they face devastating civil penalties and enforcement actions brought to them directly by the Texas Attorney General's office. Now, of course, this law came with major criticisms and opposition. Critics note that to safely comply, platforms like Apple and Google would have to force every single adult as well in Texas to upload government identification or biometric data to just prove that they are not a minor. Now, in this case, Texas's current position is built on the traditional police power of the state to protect minors from harm. Texas argues that the modern digital landscape has fundamentally altered the nature of childhood. They presented data showing that this unrestricted access to app stores and this ecosystem exposes individuals to the algorithm that can become addictive and can cause, severe data exploitation, and really could happen without any structural safeguards. So they are worried about the risk to individuals if they have unrestricted access. Texas argues that SB 2420 is also not a regulation of speech. Instead, Texas argues that this is a regulation of commercial conduct and also digital transactions. They argue that these app stores process financial transactions, takes cuts of revenue, and execute commercial contracts when a user clicks download or purchase. Because the Supreme Court historically grants states much broader latitude to regulate commercial transactions and protect consumers, Texas asserts that strict First Amendment scrutiny should not even apply here in this case. Furthermore, Texas argues that the law does not silence youth speech. They claim that it empowers parents by restoring parental rights that have been eroded by big tech platforms. Now, on the other side of the aisle, those opposing this Texas law, you have various student organizations which are represented by civil liberty groups, along with the tech industry, who are also representing themselves and trying to fight back against this law. Their argument is very clear in this case. They argue that SB 2420 is an unconstitutional system of prior restraints in violation of the First Amendment. The applicants state that the mobile applications are not just commercial widgets or physical products, they are the modern equivalent of books, pamphlets, or potentially the town square. They claim that apps are how young individuals read news, organize political rallies, practice religion, and also express themselves under the First Amendment. These groups argue that the Supreme Court's longstanding precedent firmly established that speech does not lose its First Amendment protections simply because it is distributed via a commercial platform or is exchanged digitally through this type of digital platform, or there's some sort of digital currency that is attached to it. They argue that by forcing every single citizen to prove their identity and also their age before getting access to this information, the state of Texas is creating this kind of electronic gatekeeper that is keeping people from expressing their First Amendment rights. The applicants point to several critical flaws in this Texas law, one major one being that this law was not narrowly tailored because the way that the law was actually written would require everyone within Texas to verify who they are and their age before they get access to download these apps. Now, the procedural history of this case is exactly why this case moved so fast for emergency review at the Supreme Court level and sought Supreme Court intervention. When the lawsuit was first filed, a federal district court judge issued a sweeping preliminary injunction against this Texas law, effectively just blocking it completely. The district court agreed heavily with the student advocacy groups and the tech companies, finding that the law was overwhelmingly likely to fail constitutional scrutiny because it was not narrowly tailored to serve the state's actual goals. Therefore, the judge blocked that Texas law and blocked Texas from enforcing a single piece of this law. But Texas immediately appealed up to the Fifth Circuit Court of Appeals, and on review, the Fifth Circuit granted an emergency stay of the district court injunction. By staying that injunction, the Fifth Circuit allowed Texas to immediately begin to enforce SB 2420 while the current appeal was taking place. Now, this whiplash is what forced the applicants here to file for an emergency application to vacate that stay, and they took this to the Supreme Court. So this brings us directly to the Supreme Court, their current action, and actually the Supreme Court shadow docket. Now, the shadow docket is the court's method of handling emergency requests outside of the normal kind of year-long merits review process. Because the Fifth Circuit's actions altered the status quo and allowed a highly contested law to take effect and allowed it to take effect immediately, the Supreme Court was forced to step in on that emergency basis through the shadow docket. And now we have the official order of the Supreme Court. The Supreme Court has officially issued an order regarding this emergency application, and essentially what they decided to do is deny that request of these civil rights organizations and also these tech companies. The application to vacate the stay, which was presented to Justice Alito and referred to him to the full Supreme Court, has officially been denied. So they denied review of this case, denied that emergency stay request, and so the Fifth Circuit ruling will remain in place, and also the Texas law will remain in place. This means that while the broader legal battle continues to play out at the Fifth Circuit level, they're still going to hear arguments in this case. As of right now, the Supreme Court has decided to not intervene at this early stage. By denying the application, the Supreme Court is allowing the Fifth Circuit stay to remain in place, meaning that Texas can continue to actively enforce their law, which is the App Store Accountability Act, while the formal merit stage appeal is argued and moves forward at the Fifth Circuit level. Now, make no mistake, while this is not a final permanent ruling on the constitutionality of this law itself, it is a massive procedural indicator and potential victory for Texas as of right now. The Supreme Court's choice here to leave the Texas law active for now sets a critical baseline for how these legal battles will actually proceed forward across the nation. So that is what's currently going on in this emergency Supreme Court case in response to that new Texas law. Right now, the Supreme Court has denied review to this case. They denied that emergency application, and so the Texas law will remain in place. It will be allowed to move forward and be enforced by the state of Texas, at least while the Fifth Circuit reviews this case and decides this case on the merits. So let me know what you think about this Texas law. Do you agree with the Texas law? Do you agree with the opponents of this? Do you think that this violates the First Amendment? Or generally, do you think that the state of Texas does not have a right or should not be playing the role of getting into these kind of family matters and dictating what type of content a minor should have access to? Or do you think that this is the purview of a parent? Let me know your thoughts down below in the comment section. Also, if you like this type of content and you want to get it going forward and you want to make sure that you never miss these types of updates and these types of videos, make sure you like, comment, subscribe, and also turn on all notifications to make sure you get these videos when I release them. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.